Hello, beautiful people. How you doing? It's bright as hell in here, so there's that. Happy Friday. We made it. Phew. It's good to see you. Good to be seen by you. I apologize for being a few minutes late. Thank you to Claudia for getting our goals started. We have a docket update in the appeal of the decision to dismiss Drake v. UMG. So we'll get to that in a minute. We black, so we'll get there. Just hold your horses now. Calm down. I hope that you are having the best day that you can be having under the circumstances in which we all collectively live. Shout out to all the members and the subscribers. Join them. We're almost 20,000 strong. We'll get there eventually, maybe. I don't know. Shout out to the best mod squad on the internet, constantly holding it down. Again, thank you to Claudia for getting that goal started. Shout out to Alana and to Sharina. Thank you very much for supporting the Docket Fund. You are awesome. Thank you to everybody who contributes. Throw auntie a little $2. Support the Docket Fund. Throw your auntie, throw your internet auntie. 2 little measly dollars goes a long way in supporting the educated tomfoolery we get into here. I think that's the best way to put it. Educated tomfoolery that we get into here. Hempsism, hello. Marshall Irons, hello. Tori Michelle, how you doing? Amended. Boy, I'm struggling. And I'm about to read this document. This is my warm-up. Amended. How you doing? Luna Lemon 11. Mic check that you can hear me. Appreciate you. Thank you for the support. Thank you, beautiful. Yeah. Oh, God. As you can see by the handy dandy little chart that I've put together here, we talk a lot about Drake and the Drake related litigation happening out there. And it can be hard to keep track of everything that is happening. We were just here yesterday talking about the boy and all of his petitions. So we've got California, where he's mentioned in a case where he is accused of botting to make money. He's not being sued, but it's foundational to the lawsuit. Got the class action in Missouri, which we talked about yesterday. After we finished the live yesterday, I told you all the judge is going to sign it. The judge signed it, so Missouri has been stayed. There will be a status update 90 days from yesterday. Then we've got Virginia, where he and Aiden Ross are being sued and accused of running big cash through stake in order to fund an alleged botting scheme. And then, of course, we've got the good old Southern District of New York, where the boy has filed an appeal in the dismissed case in his lawsuit against UMG. And as I said to you when he filed his appeal, appeals take a long time. It's one thing. An appeal is one thing. If you think about all of the things, all of the lives we had, all of the times we touched base on something that was filed with regards to Drake v. UMG, it was dozens of things, okay? This is just one thing. We covered all of that in a year, and this one thing is going to take at least a year. So Drake has filed an appeal, and we read his brief here on this channel. He also filed a motion for certification to appeal something that is already settled law in New York. So we read that, and we read UMG's response to that, where they say this is absurd, and it will, if granted, if the appeals court grants this, it will add at least a year to the appeal timeline. So this is going to be going on for a while, and it's a slow process. Drake filed his brief. This is one of my many alarms telling me to check my email to see if the brief has come through. Drake filed his brief, I believe, like 90 days ago. So you can see this is not like a regular litigation where the plaintiff files something and then 2 or 3 weeks later, right, we get the response from the defendant. This was Drake filed, and now 90 days later, UMG has compiled their brief for the court. And that's what we're going to look at today. I think this is the proper place for you. Just saying. You're in good company. Yeah. Yeah. It's been a long day. It's been a really long week. It's been a really long week. I've been burning the candle at both ends this week. So, if it's not clear to you, there will not be an episode of Friday Night Live tonight because that happens at 4. It's 3:25. This document is 83 pages, but I think it probably contains documents, other documents from the lawsuit that we don't necessarily need to read. So we'll see. Well, listen, when there's, potentially hundreds of millions of dollars in damages on the table, you'd go for it too. I guess. That's his thinking, right? We know that Drake she's probably got a counter on every wall in the studio, in his house, just a counter. Every time Not Like Us streams, the numbers just keep rolling higher and higher and higher. Every time they file something, they keep updating the numbers, the accolades, if you want to know how successful Not Like Us was, read Drake's amended lawsuit. All the stats and data are in there. It's crazy. I know that's right. Hey, beautiful. Well, I think he's bleeding himself, and they are just like, the blood of Christ compels you. They're just sticking their bowls underneath the wound. Shot clock counter hanging on the abs liquor mirror. Wow. Y'all are just brutal. Just brutal. All right. Here we go. I have not yet fixed the view, so I'm still, I still look like I'm looking away from the document when I'm actually not. But whatever. Thanks, StreamYard. Thanks. Table of contents. The court properly dismissed Drake's defamation claim. Not Like Us is non-actionable opinion. The rap diss track forum strongly conveys opinion. Context likewise confirms that Not Like Us is non-actionable opinion. The tone and language of Not Like Us signal non-actionable opinion. Not Like Us is not mixed opinion. Drake's remaining defamation arguments fail. Okay, so one of the things that's been really interesting about, going the length of an entire litigation with you all and seeing the back and forth that happens, it goes file, response, reply to response, right? We've seen Drake's lawyers seemingly really cite really strong case law in what it is that they're saying, and you don't need to understand cases, you don't have to be familiar with the law, you just have to go like, case law is like something that has been decided before, and so when they reference that, it's like, "Oh, well, the court has already decided this before," and they're trying to sway the judge that you should apply that to this, Your Honor, right? But then UMG would always follow up in their in their, um in their responses with like, "Well, actually, that's not what it really says," or "That's not what the decision was actually applied to," or "That's not." And as we know, by the time we got to the end of it all, is Moni here? Hi, beautiful. Everybody throw up a rose for Moni. It's good to see you. Um, so yeah, as we saw by the end of the litigation, UMG was the one that was victorious. But anyway, Drake misstates the test for assessing fact or opinion. The district court correctly took judicial notice of the other songs in the feud. That was the other thing, is Drake was trying to convince the judge, do not look at the context in which Not Like Us dropped. Judge said, but you quoted the West Coast Savior. He said, don't look at anything. Don't look at any of that. Just focus on this man released a song defaming me, and the image related to the song, Drake's house with the red icons, constitutes a map for would-be assailants to harm him. Remember, Drake said that Not Like Us constituted second degree. What was it? Was it second degree harassment or second degree assault? I genuinely can't remember. I'm so tired. I'm so sorry. Yeah. Wow. My brain just totally just blanked. Anyway. Oh, yes, harassment. Okay, thank you. All I got to do is look at the document. It was harassment. So, Drake's republication argument is meritless. So this matters because damages for published works, if they are found to be defamatory, damages can be impacted by how many times the material was published. And one of the things that Drake claims to the court is, for example, every time UMG licensed the song, that constituted a republication. So we've talked about potential damages before. If Drake said, I want a quarter, 25 cents, for every single time Not Like Us has been streamed, audio version. We're not even going to get to the video. Let's just do the audio version. That is hundreds of millions of dollars in damages. Okay. Well, thank you so much. We've been doing lots of spring cleaning around these parts. Thanks for noticing. There was a bunch of dangerous language in Drake's lawsuit. He basically said Kenny was an anti-Semite. Right. It didn't have anything to do with, and it doesn't, but it doesn't have anything to do with, Drake being half white. It has to do with Drake being Jewish. That lawsuit is dangerous in so many ways. And it's slipped in such a way that if you didn't read it 86 times, you would miss it. You would miss just how insidious the implied accusations are about Kendrick Lamar and his motivation and intention behind releasing the song. According to Drake, Kendrick's intention behind releasing the song, and therefore the image that goes with it, was for Drake to be harmed. And he said explicitly that UMG didn't care if he was physically assaulted or worse. So he's alleging that UMG didn't care if he was murdered in this entire situation. So there's all of that, and then there is the complete threatening of rap as an art, and for rap then to be judged that way. And then the First Amendment for everybody. It's not once it becomes case law, it's not something that's just applied to rap. It's applied to commentary. I mean, it's already applied to commentary, but it's applied to the things that you write, the things that you say, the opinion that you give in a way never done before. It would alter the protection of the First Amendment. So Drake sued for defamation, second-degree harassment, and then violation of New York general business law. So they respond to all of that in this document. And then they have, I'm sure, a very long list of a table of authorities. Let's see how many pages it is. 1, 2, 3, 4, 5, 6, 7. In spring 2024, superstar rap artist Drake and Kendrick Lamar, artists, plural, Drake and Kendrick Lamar, had perhaps the most infamous rap battle in the genre's history. They slung at each other a series of diss tracks, a mainstay of the rap genre, in which artists seek to one-up each other with mockery and verbal disrespect. This vitriolic war of words took on increasingly heated rhetoric, loaded accusations, and violent imagery. I'm reminded that I need something. Okay. After Drake's tracks accuse Lamar of beating his fiancée and not fathering one of his children and encouraging Lamar to talk about Drake liking young girls, Lamar issued his final track in the series, Not Like Us, hurled profane and hyperbolic insults at Drake about many subjects, including taunting, "Say Drake, I hear you like 'em young," and mocking Drake and his crew as certified pedophiles. The latter riffed on Drake's 2021 album, Certified Lover Boy. Not Like Us dealt the metaphorical killing blow. The track became one of the most popular and critically acclaimed rap tracks ever, winning multiple Grammys. After losing the battle, Drake sued UMG, the record company to which both he and Lamar are signed. Although Drake had used UMG's platform to attack Lamar in equally incendiary terms, he now claims UMG defamed him by releasing the recording that the track violates New York penal law and that UMG's promotion of it violated New York general business law. The district court dismissed, applying settled New York law, which I mentioned earlier. It recognized that whether statements convey fact or opinion depends on full context, including form, tone, language, and surrounding circumstances. The court correctly held that Not Like Us, a diss track released during a rhetoric-drenched rap battle and full of Hyperbole. Boasts and insults would be understood by a reasonable listener as opinion. Drake does not show otherwise on appeal. Drake does not show otherwise on appeal. Instead, he seeks to strip words from their context and deem them actionable defamation if anyone, anywhere might treat them as factual. That is not the law, and Drake's view would critically undermine a highly creative art form built on exaggeration, insult, and wordplay. Drake's penal law and GBL arguments fare no better. What did I miss? Drake does not show, the court should affirm the dismissal. Statement of the issues. Did the court correctly hold that Drake's defamation claim fails because not like us constitutes non-actionable opinion? Did the court correctly hold that New York penal law does not imply a private right of action, or does the claim fail for independent reasons? Did the court correctly hold that Drake failed to state a GBL 349 claim? And then it goes through who the parties are. And okay, so the parties. Usually I skip this, but no, I'm not gonna. UMG is a global music company that contracts with some of the biggest artists in the world. These artists include Drake and Lamar, both world famous performers. Drake is one of the best-selling music artists of all time. Lamar also has sold hundreds of millions of albums and has won a Pulitzer Prize. I'm bulletproof. You ever be in that situation where you think it's cool and you walk by and the belt gets you? Yeah. Yeah. Maddie Warhol. Look at our favorite child. It's hilarious that Drake's claims are in quotes and Kendrick's are just stated facts. Well, so here's the thing that's funny. So all of these quotes that you see are from filings in the lawsuit. So they're things that the court can pull. It's telling them where to go to find where this was in a document already in the case. But that language about Kendrick Lamar winning a Pulitzer Prize is brand new language. I don't think that it was even brought up during the lawsuit. I could be wrong, but I feel like this is the first time I've said that reading a Drake v. UMG related document. Damn. Yeah. Drake is one of the best-selling music artists of all time. Lamar also has sold hundreds of millions of albums and has won a Pulitzer Prize. Oh, UMG, you never fail me when it comes to these documents. Really. The rap beef. Competition and verbal sparring have been integral to rap music since the art form's inception in the 1970s. Braggadocio, hyperbole, and competitive wordplay are among rap's most defining artistic practices, where exaggeration and lyrical cleverness take precedence over the truth. Indeed, rap scholars trace rap's roots to the dozens, a verbal game in which participants trade insulting rhymes until one's opponent is unable to respond. We had a wonderful conversations for the culture with the rap scholars who filed an amicus brief in Drake v. UMG. So that is referenced here. And it's extremely possible that they could be working on an updated brief to the appeals court, and we could see that come onto the docket after this. Wouldn't that be interesting? As he should. That would be super cool. Yeah. Yeah. I asked them about that in the interview, and they said we'd have to write a new one. And I believe he said, and I'm paraphrasing, it's been a minute, that they were at least discussing that. So, but it would be cool. Okay. Rap battles and diss tracks are often vicious, graphic, and hyperbolic, and rap lyrics regularly contain accusations of disreputable conduct, including illegal behavior. Rap's history is rich with these battles, and Drake is a prolific combatant, having traded diss tracks with many artists before Lamar. In 2024, Drake and Lamar had a rap beef. They traded several diss tracks, sometimes within the same hour, laced with progressively caustic, inflammatory insults and accusations. Oh my god. This is how we know that the rap scholars amicus brief was helpful to UMG, because they reference a book that is cited in the rap scholars amicus brief. Talking about your mama, the dozens, snaps, and the deep roots of rap. Oxford University Press, 2014. See also Callie Ingram, 13 times Drake has had beef with other rappers, including Kendrick Lamar, Pusha T, and Kanye West. Business Insider. Congratulations, Callie. Their feud became a massive cultural phenomenon. On April 19, 2024, Drake released a diss track directed at Lamar called Push Ups. Drake mocks Lamar's height and shoe size and questions Lamar's success. How the fuck you big steppin' with the size 7 men's on? Pipsqueak pipe down. A few days later, impatient with Lamar for not having responded, Drake released Tailor Made Freestyle, in which he used artificial intelligence generated voices. In which he used artificial intelligence generated voices of deceased rapper Tupac and rapper Snoop Dogg to goad Lamar into responding. In Tupac's voice, Drake encouraged Lamar to talk about Drake liking young girls on his next track. Drake, in his own voice, further taunts Kendrick for failing to come up with a satisfactory response. You trying to let this shit die down? Nah, not this time, nigga. You following through. What the fuck is taking so long? We waiting on you. Sounds like a ghetto ass Valentine's Day card. What the fuck is taking so long? I'm waiting on you. Sounds like a ghetto ass Valentine's Day card. Lamar answered by releasing Euphoria on April 30, which accused Drake of fabricating his claims. It blasts Drake's music. Parenting. I got a son to raise, but I can see you don't know nothing about that. And character and identity. On May 3rd, 2024, the feud between Drake and Lamar escalated as they lobbed increasingly vicious personal accusations at each other over the course of the day. Lamar released 616 in LA, which calls Drake a terrible person and a bully, among a volley of taunts, and asserts, everyone inside your team is whispering that you deserve it. Drake responded that day with Family Matters, a blistering attack that criticized Lamar's authenticity, calls into question whether Lamar is the biological father of one of his children, jabs at Lamar's relationship with his partner, suggests Lamar cheats on her, claims that Lamar is a domestic abuser, makes violent allusions. Almost immediately after the release of Family Matters, Lamar unleashed the scathing Meet the Grams, which says that Drake is a deadbeat father, among scorching attacks. The next day, Lamar released Not Like Us. Like the preceding tracks, it is thick with epithets, rhetoric, and hyperbole. Lamar profanely mocks Drake. You nigga will get a wedgie, be flipped over your boxers. Why you trolling like a bitch? Ain't you tired? What's up with these jabroni ass niggas trying to see Compton and his brand OVO? What OVO for? The other vaginal option? Pussy. What is the owl? Bird niggas and bird bitches. And calls Drake a liar who exploits other artists. You not a colleague. You a fucking colonizer. Taking up Drake's above mentioned invitation to talk about Drake liking young girls, Lamar makes the statement at issue here. Say, Drake, I hear you like him young. You better not ever go to cell block 1. To any bitch that talked to him and they in love, just make sure you hide your little sister from him. They tell me Chubb's the only one that gets your hand-me-downs. And party at the party playing with his nose now. And Baca got a weird case. Why is he around? Certified lover boy, certified pedophiles. Also, trying to strike a chord and is probably a minor. Your homeboy needs subpoena, that predator moving flocks, that name got to be registered and placed on neighborhood watch. The cover art for Not Like Us is an image of Drake's Toronto mansion, obviously doctored to appear as if dotted with 13 sex offender markers. We like footnotes here. OVO, which is used for Drake's record label and a clothing company, has an owl logo. Chubbs, Party, and Baca are associates of Drake's. Baca was arrested in 2014 on human trafficking and assault charges, then convicted of assault. Sam Pisano, Drake entourage member, guilty of assaulting woman in Toronto's son. Okay. Drake responded the following day with the Heart Part 6, which re-ups the themes that Lamar commits domestic abuse and did not father one of his children. It says that Drake anticipated the very taunts that he now claims are defamatory. This Epstein angle was the shit I expected, TikTok videos you collected and dissected, and denies them. I'd never look twice at no teenager. On July 4, what a patriotic day indeed that was. Amen. Amen. Lamar released the Not Like Us video. It is replete with exaggerated and non-literal imagery. For example, it opens with Lamar whispering to a clown that he sees dead people, a nod to the film The Sixth Sense, implying hyperbolically that Drake has been defeated in the rap battle. Again, owl imagery alludes to Drake's brand OVO, with Lamar seen beating an owl piñata. Not Like Us was 2024's best-selling rap track, and Rolling Stone deemed it 2024's biggest moment in music. It won 5 Grammy Awards, Record of the Year, Song of the Year, Best Rap Performance, Best Rap Song, and Best Music Video. Lamar performed a live version at the Super Bowl halftime show in February 2025. Weeks before the Super Bowl performance, Drake filed suit asserting claims for defamation, second-degree harassment, and under general business law. The GBL claim, that's the general business law, was based on the false assertion that UMG used bots to stream Not Like Us. Bots are software programs, okay, blah, blah, blah. That assertion was directly refuted by the source Drake relied on. After UMG sent a Rule 11 letter, Drake agreed to withdraw and correct the allegations. Drake filed an amended complaint on April 16, 2025, asserting the same 3 claims. The district court granted UMG's motion to dismiss in full, relying heavily on authorities by this court and the New York Court of Appeals. On defamation, the court recognized that New York's Constitution provides for absolute protection of opinions. It explained that courts must therefore determine, as a question of law, whether challenged statements convey fact or opinion by considering whether the full context of the communication signals to reasonable readers or listeners that what is being read or heard is likely to be opinion, not fact. Applying that framework, the court held that Not Like Us cannot reasonably be understood to convey factual matter. It analyzed the forum in which Not Like Us was published, the surrounding circumstances, the tone and language of the song, and its apparent purpose. The court concluded that the forum of Not Like Us, a rap diss track, would not convey to the reasonable listener that it is the product of a thoughtful or disinterested investigation, conveying fact-checked, verifiable content. The court reasoned that surrounding circumstances, the track was published as part of a heated public feud in which both participants exchanged progressively caustic, inflammatory insults and accusations, provided precisely the type of context in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole rather than factual assertions. That was one sentence. And the track's language and tone reinforce that it can only reasonably be understood as opinion because it is replete with profanity, trash talking, threats of violence, and figurative and hyperbolic language, all of which are indicative of opinion. The court found, upon a full consideration of the context in which Not Like Us was published, that a reasonable listener could not have concluded that the song was conveying objective facts about Drake. Using that contextual analysis, the court also rejected Drake's contention that Not Like Us constitutes actionable mixed opinion. The court dismissed Drake's harassment claim, holding that New York penal law does not create an implied private right of action. The court reasoned that recognizing a private right of action would be inconsistent with the legislative intent, as the legislature conferred authority to enforce the criminal harassment statute upon local law enforcement. Finally, in dismissing the GBL claim, the court primarily found Drake's information and belief pleadings insufficient to plausibly allege that UMG engaged in a deceptive scheme to inflate the popularity of Not Like Us. It also held the claim failed because Drake did not allege how UMG harmed consumers. Drake appealed. Upon docketing, he moved this court to certify the implied right of action question to the Court of Appeals. This court referred that separately brief motion to the merits panel. Hello, beautiful. It's good to see you. Thank you, everybody, for your super chats. I will get to them. I'm just saw this one out of the corner of my eye. Wanted to say hi and thank you for the few seconds that you're popping in. The court correctly held that Drake's defamation claim failed because Not Like Us constituted non-actionable opinion. The court followed the Court of Appeals' long line of precedents, holding that context is critical to distinguishing between opinion and factual claims. And this court's application of those rules in Michael Rappaport versus Barstool Sports and Terrain v. Liu to reject defamation claims as a matter of law where the complaint of statements arose, as here, in a war of words. This presents a clearer case for affirmance than Rappaport and Terrain. Everything about this context, large and small, confirms opinions are not at issue. Not Like Us falls within a genre typified by inflammatory put downs. Put down. I haven't heard the word put down. I probably decades. That takes me back to when I worked with kids or worked in a school. Not Like Us falls within a genre typified by inflammatory put downs, epithets, fiery rhetoric, vulgarity, and hyperbole. And this particular diss track delivers in spades, bouncing from allusions to the crucifixion, to pop culture infused double entendres, to braggadocio about Lamar's superiority vis-a-vis Drake and Lamar's hometown, to put downs about Drake's crew, relationships, brand, authenticity, artistic prowess, and hometown, all the way to the pedophilia-related taunt about which Drake complains. Moreover, Not Like Us capped off a high-profile rap battle in which Drake and Lamar traded a string of caustic, inflammatory diss tracks. Drake dissed Lamar regarding, among other things, philandry, domestic abuse, and Lamar's height, career, and authenticity, and urged Lamar to talk about Drake like in Young Girls. Drake's attempt to rip the words he now dislikes from their immediate and broader context has no support in governing law, nor does Drake's fallback claim that two lyrics in Not Like Us imply undisclosed facts. The same relevant context forecloses that argument. And Drake's last-ditch effort to identify some threshold legal or procedural error in the district court's approach is equally meritless. The district court's work was careful, methodical, and comported fully with controlling law. The district court properly dismissed Drake's supposed implied right of action for second-degree harassment. The Court of Appeals has specifically limited the availability of implied rights, and nothing about this criminal statute meets those standards. Tellingly, the legislature expressly enacted a civil claim to enforce a neighboring provision of the penal law, but declined to do the same for the part Drake invokes. The appellate division has squarely rejected that there is a right of action. Even if one existed, Drake's claim would fail because he cannot satisfy many of the statute's requirements. Drake's general business law claim fails because his information and belief allegations, resting largely on anonymous online commentary, do not plausibly plead deception. The court also correctly held that Drake did not allege consumer-oriented harm, and his alleged injury is derivative and speculative. In assessing whether plaintiff has stated a plausible claim to relief, the court must consider the complaint in its entirety, as well as other sources courts ordinarily examine when ruling on motions to dismiss, in particular, documents incorporated into the complaint by reference and matters of which a court may take judicial notice. Some of this is very repetitive. So, under New York law, expressions of opinion, as opposed to assertions of fact, are deemed privileged and, no matter how offensive, cannot be the subject of an action for defamation. Whether a statement is opinion or rhetorical hyperbole, as opposed to a factual representation, is a question of law for the court. Thus, defamation claims are routinely resolved at the motion to dismiss stage. There is particular value in resolving defamation claims at the pleading stage so as not to protract litigation through discovery and trial and thereby chill the exercise of constitutionally protected freedoms. In determining whether challenged statements convey fact or opinion, the legal question is whether the statements would have been understood by a reasonable audience as assertions of fact that were proffered for their accuracy. Courts consider, number one, whether the specific language in issue has a precise meaning which is readily understood. It does. Two, whether the statements are capable of being proven true or false. Questionable in this situation. We've had a lot of discussion on this channel about Drake saying that he is not a convicted PDF. And what I said to you off rip immediately is that the legal standard for determining whether or not somebody is a PDF? I think not. Conviction is the standard? Where? That's not the standard. That's not what determines that. And Kenny didn't say you were convicted. He said rhetorically, they should be placed on neighborhood watch. He never said anything about convicted, but that's what Drake put in his filings. I am not a convicted PDF. Okay, what's your point? Okay. 3, whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. In this case, yes. The third context factor is critical. The context inquiry is holistic. Courts are required to take into consideration the larger context in which the statements were published, including the nature of the particular forum and the content of the communication as a whole, including its tone and language and apparent purpose. The district court looked first to the forum or medium at issue, a rap diss track, which it rightly held signals non-actionable opinion. Courts regularly find that the genre and medium of challenge speech support a conclusion that the speech is opinion, even where other factors suggest the words could convey factual claims. In doing so, the Court of Appeals has consistently held that the common expectation of readers or listeners in a particular forum is highly significant. Applying these rules, this court has concluded that defamation claims fail as a matter of law in mediums like this one. In Michael Rappaport v. Barstool, this court affirmed dismissal of defamation claims premised on a 6-minute long fire rap diss track video in which defendants, Barstool, rapped a constant stream of insults and slurs about Michael Rappaport, which occurred mid-war of words between entertainers. This court did so notwithstanding that the statements accusing Rappaport of having herpes and stalking and physically abusing his ex-girlfriend obviously could be deemed factual in other mediums like a news program or a journalistic piece that encourage the reasonable reader to be less skeptical and more willing to conclude that they stated or implied facts. So a song is not the medium for facts. A newspaper article by a reputable investigative journalist, the audience, the reader, is going to have a heightened expectation of you've done your due diligence and you're presenting me with factual, objective information. The same is true in this case. A rap diss track signals, if not shouts, opinion, not fact. It is the quintessence of an art form expected to contain considerable hyperbole, speculation, and diversified forms of expression and opinion. There is no common expectation of finding factual statements in rap tracks, especially diss tracks. They are not where a reasonable audience turns to find the rigorous and comprehensive presentation of factual matter, let alone factual claims about a rival's predilections or unlawful conduct. The reasonable listener would not typically view statements in diss tracks to represent factual assertions about the opposing artist, but rather to demonstrate skill and dominance through clever wordplay, bluster, and demonstrations of disrespect. This is especially so when, consistent with the genre, the pedophile's language on which Drake fixates is plucked from a series of hyperbolic disses, including taunts that Drake is a jabroni, stupid-ass nigga, and fucking colonizer. His skills make him akin to a ball boy, not a player like Lamar. He lacks street cred and owes others for his lingo. I'm dead. I'm dead. I'm gonna read that again. Consistent with the genre, the pedophile's language on which Drake fixates is plucked from a series of hyperbolic disses, including taunts that Drake is a jabroni, stupid-ass nigga, and fucking colonizer. His skills make him akin to a ball boy, in parentheses, not a player, like Lamar. He lacks street cred and owes others for his lingo. Accordingly, the district court rightly concluded that the average listener is not under the impression that a diss track is the product of a thoughtful or disinterested investigation, conveying the public fact-checked, verifiable content. The things that I'm skipping over are either repetitive or case law that will distract. Drake essentially concedes this. He barely addresses the court's reasoning and lacks rejoinder to such authorities. As to forum, he merely asserts that the court created a categorical rule that defamation in rap cannot give rise to a cause of action so long as the rap also includes profanity or threats of violence. That blatantly mischaracterizes the holding. Yes, it does. Thank you, beautiful. Drake? Hey, beautiful. Shout out to everybody who's watching. Quite a large little group of folks here. Hit your auntie $2 for that docket fund. Oh my goodness gracious. We are on page 23 of 83. Let's hope there's attachments contained herein that we don't necessarily have to read because we read them before, because we've read everything filed in Drake v. UMG on this channel. Wrote a book about it too, actually. The selection of quotables is fantastic. Baby, everything counts towards the docket fund. But of course, YouTube takes a cut and it also takes a really long time to get to me. And so, Cash App and Venmo are also options as well. We're working on paying down the first quarter 2026 docket fund bill currently. Okay. Rather than announce any categorical rule, the court stated the opposite, noting that the form in which a statement appears is not dispositive of the facts versus opinion inquiry, but instead provides contextual indication that can inform the court's analysis. It nowhere indicated that a diss track could never be defamatory. It simply recognized that the average listener in this forum and common expectation for statements in this forum were significant. It held, including in light of those considerations, that this diss track could not be understood by a reasonable listener as conveying fact. That approach tracks Court of Appeals precedent. For example, the court has held that an article's appearance in an opinion section does not automatically insulate the author from liability for defamation, but emphasized that the form in which a statement has been made is a useful gauge. At best, Drake's categorical rule argument is really a gripe that the forum specific common expectation inquiry is misguided. But controlling law dictates that inquiry, and Drake identifies nothing to suggest that the court misapprehended the common expectation for diss tracks, much less this particular track. Additionally, in trying to prop up his categorical rule contention, Drake mischaracterizes the court's analysis of the tone and language of Not Like Us. Drake contends that on the court's logic, so long as a song includes profanity and threats, it is immune from defamation liability. That grossly oversimplifies the court's assessment of tone and language. Again, it created no categorical bar based on magic words or themes. They said Drake is engaged in magical thinking. If you know, you know, but magical thinking is actually a term for certain kind of thinking. Okay? Yeah. Instead, after correctly explaining that loose, figurative, or hyperbolic statements and imaginative expressions have repeatedly been held to signal non actionable opinion, the court found that Not Like Us is replete with profanity, trash talking, and threats of violence, and figurative and hyperbolic language. Finally, Drake argues that the district court's purported categorical rule ignores that rap music can convey factual assertions because rap lyrics are regularly used as evidence in criminal cases. Beyond the fact that the district court imposed no such rule, Drake's argument is nonsensical. And it's also hypocritical as hell. Mister, let me be a top line signer of a petition that rap lyrics should not be used in court. Remember that? Drake, you remember that? Drake's argument is nonsensical. Whether rap lyrics are admissible as evidence for the jury to weigh in determining whether factually a crime has been committed is distinct from the issue here, where the court must consider as a matter of law whether a reasonable person would understand not like us to convey opinion. Drake's argument is also astoundingly hypocritical. In November 2022, Drake signed a petition criticizing the trend of prosecutors using artists' creative expression against them by treating rap lyrics as fact. The petition decries that more than any other art form, rap lyrics are essentially being used as confessions in an attempt to criminalize Black creativity and artistry, and that the use of lyrics against artists in this way is un-American and simply wrong.
I study rap battles for a living.
The district court next considered the surrounding circumstances in which this diss track was released. The court rightly found that broader context also signals opinion. As the New York Court of Appeals has explained, even apparent statements of fact may assume the character of statements of opinion when made in public debate, heated labor dispute, or other circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. It goes through Rappaport again. The surrounding circumstances signal to the reasonable listener that the complained of statements convey opinion. Wow. Drake's attempts to distinguish Rappaport fail. His argument that it involved summary judgment is a red herring, as there was no motion to dismiss there, and both the district court and this court ruled as a matter of law. His suggestion that the statements in Rappaport did not make serious allegations is nonsense, as shown. He also argues that the diss track video in Rappaport described the history of the dispute between the parties, which contextualized for the audience that they were part of a feud. But there were approximately 80 statements at issue in Rappaport, any number of which did not include such background. This diss track was released in perhaps the most infamous rap battle in the genre's history, a vitriolic war of words between Drake and Lamar, in which they traded a series of diss tracks that contained increasingly heated rhetoric, loaded accusations, and violent imagery. Not Like Us was Lamar's final track in the feud that followed Drake's tracks accusing Lamar of domestic abuse and implying he was not the father of one of his children. If ever there was a circumstance for the audience to anticipate the use of epithets, fiery rhetoric, or hyperbole, this is it. In response, Drake wrongly argues that the court's context review was both too broad and too narrow. To start, these arguments isolate and emphasize individual factors in the court's opinion to mischaracterize its holistic contextual analysis. The court did not find that the statements at issue were non actionable opinion only with reference to other songs in the feud. That broader context was one aspect of the court's comprehensive analysis in which everything signals opinion. Regardless, both of Drake's arguments fail. The district court did not define the context too broadly. In Drake's strained, they put strained in parentheses. We actually have parentheses merch. Oh my God. Oh my God. In Drake's strained view, because of the cultural ubiquity of Not Like Us, the court should ignore the broader context that gave rise to the song and assess it as a singular entity. The district court rightly rejected this argument. Drake's argument fundamentally misunderstands New York defamation law. Drake would have this court ignore the broader context entirely, save for assessing modern attitudes towards allegations of pedophilia. Remember that? Remember when he said we were all a part of a mindless cult of non-thinking people? Right. He argues that defining the context as the entire rap battle, including the 6 songs that preceded the recording, is improper because global listeners of the recording, Not Like Us, would not necessarily have known about the rap battle between the two. In effect, Drake seeks to roll back 40 years of state defamation law and replace New York's standard for assessing whether statements convey fact or opinion based on an assessment of the full context with the narrower federal standard that the Court of Appeals has not followed since a case that happened in the 70s, I think. And we talked about this before, where I told you all Drake appears to have just leaped over a significant portion of litigation history where things became settled law, and has gone back to just before that to justify some of his arguments, which is crazy work. Crazy work. Okay. Repetitive. Hmm. The court cannot assess Not Like Us in a vacuum. The context of the vitriolic rap beef that gave rise to the song is central. Here, that factual context is the insults and trash talking that took place via these diss tracks in the days and weeks leading up to the publication of Not Like Us. As the district court summarized, the songs released during the rap battle are in dialogue with one another. They reference prior songs and then respond to insults and accusations in prior tracks. Indeed, understood in context, Lamar's lyrics, Say Drake, I Hear You Like I'm Young, calls back to Drake's lyrics in Tailor Made Freestyle to talk about him liking young girls. That's a gift from me. Heard it on the Button podcast. It's gotta be true. As much as Drake may dislike that context after the fact, it is fair game and critical to consider under New York law. Even putting aside the lyrics of the other songs, the fact of the feud itself signals to the reasonable listener that Not Like Us conveys opinion. It was not just the recording which gained a cultural ubiquity, but the rap battle itself. It blinks reality to suggest that perhaps the most infamous rap battle in the genre's history has not become ubiquitous. Thus, as in Rappaport, the release of Not Like Us in the midst of a public and very acrimonious rap battle between Drake and Lamar that would have been obvious to even the most casual observer, especially when coupled with the form and language and tone of the track, signals to the reasonable listener that it is opinion. Paradoxically, Drake argues that the court's context definition was simultaneously too narrow. Drake contends that the court needed to consider how the reasonable listener would understand the defamatory statements in the broader social context of modern attitudes towards allegations of pedophilia and sexual abuse. The argument is telling. Drake, who would have the court ignore entirely the broader feud in which Not Like Us is obviously situated, seeks to invoke modern attitudes to effectively convert any statement touching on pedophilia or sexual abuse to one of fact. Drake offers no authority to support this move. There is simply no special rule of law making criminal slurs actionable regardless of whether they are asserted as opinion or fact. And the factual underpinnings for Drake's argument put him on a limb. He contends that societal attitudes to sexual improprieties have evolved in the context of the downfall of rappers like R. Kelly and Sean Diddy Combs. Neither R. Kelly nor Combs was brought down by a diss track. They were indicted by federal prosecutors and convicted by juries. Finally, the district court exhaustively considered the tone and language of Not Like Us. In holding that they also convey opinion, the court's analysis was again steeped in appellate precedent. Statements laden with epithets, vulgarities, and non-literal language and imagery signal opinion. Not Like Us drips with these markers of opinion. It is replete with profanity, trash talking, threats of violence, and figurative and hyperbolic language, all of which are an indicator of opinion. A reasonable listener would not equate a song that contains lyrics such as "Ain't no law boy, you ball boy, fetch Gatorade" or something. Since 2009, I had this bitch jumping with accurate, factual reporting. The same is true track wide. No sober, factual analysis is conveyed by passages like "Certified Boogeyman, I'm the one that upped the score with him. Walk him down whole time, I know he got some hoe in him." Or "You nigga will get a wedgie, be flipped over your boxers." Indeed, Drake admits that even the excerpts about which he complains use figurative language. In a play on the dual meaning of a minor, a person under the age of 18, and a musical scale, the recording says that Drake is trying to strike a chord and it's probably a minor. That is a brilliant point to make. Drake admits that even the excerpt about which he complains uses figurative language. And then they quote Drake's filing in a play on the dual meaning of a minor, a person under the age of 18 and a musical scale. The recording says that Drake is trying to strike a chord and it's probably a minor. They have quoted Drake. Back to Drake. The same is true of the cover art and the video. The cover, an image of Drake's mansion overlaid with sex offender markers, is obviously doctored, further underscoring the non-factual nature of Not Like Us. As the district court observed, no reasonable person would view the image and believe that, in fact, law enforcement had designated 13 residents in Drake's home as sex offenders. It is figurative, hyperbolic, and exaggerated. Classic opinion. The video is similarly laden with vulgarities, epithets, and non-literal imagery. Lamar skips hopscotch while singing the A minor line, hardly suggestive of objective reporting. Lamar also beats an owl piñata with the disclaimer, "No OV hoes were harmed during the making of this video." No reasonable person would need a disclaimer that the piñata is not literally Drake and his crew. The imagery is satirical, figurative, and hyperbolic. All of the relevant context related considerations demonstrate that Not Like Us conveys opinion. Taken together, as they must be, the court below got the result exactly right. The statements in Not Like Us were largely laden with delivered in the midst of a public and very acrimonious dispute between Drake and Kendrick that would have been obvious to even the most casual observer, and released in a rap diss track, a platform where audiences reasonably anticipate hearing opinionated statements. This court should affirm the dismissal of Drake's defamation claim. Now let's talk about rabbit holes and how further they go. Not Like Us is not mixed opinion. Drake's fallback position is that even if Not Like Us conveys opinion, it constitutes actionable mixed opinion. He says two lyrics leave the impression that Lamar has insider knowledge of Drake's alleged sexual misconduct. They are, rabbit hole is still deep. I can go further, I promise. And say, Drake, I hear you like 'em young. The district court rightly rejected this argument. The governing legal framework is essentially the same as above. A reasonable person standard is used to assess as a question of law whether a statement implies undisclosed facts, making it mixed opinion. The rabbit hole is classically fantastic, not home for factual fodder. As the district court noted, it is not at all clear that Drake's framing is a natural reading of this lyric. Regardless, the argument fails as a matter of law for all the reasons otherwise discussed. The court's decision, no, I'm not going to do that. Hold on. This court and others have rejected mixed opinion arguments like Drake's, where, as here, the challenge statement implicates controversies that are widely known or reported. Here, rumors about Drake's relationships with minors predate Not Like Us and have been widely reported. Lamar is indicting Drake for years of rumors and speculation around his misbehavior around minors. Finding that Drake's invitation in Tailor Made Freestyle that Lamar should talk about Drake liking young girls clearly prods Lamar to discuss pre existing rumors about Drake's interests in minors. Drake confirmed that he understood the track to refer to this history. The Epstein angle was the shit I expected, only fucking with Whitney's, not Millie Bobby Brown's. Drake has no meaningful response. He primarily resorts to another case, a case that nowhere mentions mixed opinion. He otherwise quotes lyrics from other songs in the feud about which he made no argument, arguing that the court erred by drawing inferences against him from those songs in its contextual analysis without crediting that they could lead reasonable listeners to believe that Lamar has undisclosed information. But this argument fails as discussed because it improperly seeks to convert a question of law into a matter of fact. And the district court rightly found in deciding the relevant question of law that lyrics like those Drake cites, plus those in his own songs, such as Your Darkest Secrets Are Coming to Light, and What About the Bones We Dug Up in That Excavation, show that during this rap battle, Drake and Lamar each use similar threatening, hyperbolic language. Accordingly, no reasonable listener could understand the statements to imply undisclosed facts, but would see them instead as posturing in a rap diss track. Drake's remaining defamation arguments fail. Unable to show error in the court's context-based analysis, Drake fishes. Y'all been watching the channel. Aw, shucks. Unable to show error in the court's context based on analysis, Drake fishes for some anecdotal, legal, or procedural error. This fails. Drake asserts that a defamation claim should survive if any reading of the complained of statements could implicate factual representations, relying on anonymous online comments. Endorsing Drake's position would turn the law upside down. The Court of Appeals and this court have repeatedly cautioned against interpreting words divorced from their context. Drake's argument is irreconcilable with that approach, and egregiously so because it primarily relies on roughly 60 cherry-picked anonymous online comments from handles like at random for YouTube 3215 and I am Chicken Little, and of course at meow meow 1234 meow. Stickers and magnets coming soon to the store. Not only are these comments irrelevant to the court's context analysis, but Drake fails even to grapple with whether the commenters were making factual statements or whether they too were stating opinions. Moreover, this court has rejected precisely the argument that because someone treated something as fact, the reasonable person test must be met. In Rappaport, plaintiff argued that the district court incorrectly overlooked evidence that Barstool's audience interpreted the alleged defamatory statements as true on the basis that Rappaport's podcast received thousands of negative statements in the aftermath of Barstool's campaign, including comments repeating and expanding on the challenged statements. This court disagreed. Drake is effectively seeking to impose something akin to a least sophisticated consumer standard that has never been recognized in New York's defamation law. Additionally, Drake says entertainment industry insiders and media experts also interpreted the recording as factual. Even if these were a proxy for the applicable reasonable person standard, neither supports his assertion. And then they cite NPR and Seth Rogen. So they said Drake needs you to lower the standard down to the gang of gambling degenerates, that's quote, that are dumb. Because those people believed it. Lower your standard down to the dum-dums. Neither Drake's invocation of case law nor anything else he cites supports his attempt to rework the governing standard or allow online comments to carry the day. Case law does not involve reliance on anonymous online comments to resolve the fact opinion question. More fundamentally, case law instructs that context is critical. Case law applies the same fact opinion test enshrined in other case law and its progeny, finding there that the statements referencing a university investigation implied the speaker had, okay, blah, blah, that's case law. Drake also argues that the district court erred by reaching beyond the pleadings to draw factual inferences from judicially noticed lyrics in tailor-made freestyle. The diss track in which Drake used the AI-generated voice of deceased rapper Tupac to urge Lamar to talk about Drake liking young girls. Drake complains that rather than simply acknowledging the lyrics' existence, the court relied on them in assessing the broader context and used its subjective interpretation of the lyrics to contradict Drake's allegations. This argument fails many times over. First, Drake assumes that there is another interpretation of talk about Drake liking young girls, but Drake's counsel could not provide the court with any alternative understanding of this lyrics at oral argument, nor does his brief here. There is not one. Second, this court reviews the district court's determination of whether to take judicial notice of facts for abuse of discretion. And Drake does not attempt to show such an abuse. Third, Drake waived any such challenge below by conceding at oral argument that the court could take judicial notice of the other song lyrics. We don't, quoting from the transcript, which I read here, Drake's lawyers, we don't challenge that the court can take notice of the facts that the lyrics exist in a song out in the world, end quote. Fourth, courts may take judicial notice of song lyrics because they can be obtained from widely available and reliable sources, the accuracy of which cannot reasonably be questioned. Fifth, Drake's argument that the court erred in drawing inferences against him conflates a question of law with a question of fact. Drake's tortured, in parentheses, logic is that the court took notice of tailor-made freestyle for the truth of the matters asserted and drew factual inferences against him by finding that the only inference a reasonable listener could make from an artistically projected and AI-generated voice of Tupac was a factual message from Drake designed to goad Lamar into making pedophilia allegations against him. That was a lot. Basically, at one stage, Drake's lawyers said that Drake did not invite Kendrick Lamar to accuse him of being a pedophile. And in no way did he, condone UMG releasing such a song. So it wasn't actually an invitation. The court obviously did not take notice of tailor-made freestyle for the truth of the matters asserted. Doing that would have required it to find the lyrics were true. It also did not make findings of fact. Rather, it considered as a question of law whether the reasonable listener would understand Not Like Us to convey fact or opinion, and as part of that analysis, situated the song in the context of the broader rap feud. As discussed, extensive precedent, including this court's Terrain decision, shows that the district court was right to consider this broader context. Drake does not cite a single defamation case in support of this argument, and for good reason. The focus on context, not merely what words might mean in the abstract, necessitates that courts frequently draw legal conclusions that disfavor a defamation plaintiff's proposed cold reading of a challenged statement. Drake's republication argument is meritless. Drake argues that the court erred by overlooking UMG's purported republications of Not Like Us. According to Drake, UMG republished the track by releasing the music video, permitting the recording to be played at 2 political rallies and the Grammys, and allowing Lamar to perform the song at a Juneteenth pop-out concert, and arranging for it to be performed at the Super Bowl. Drake says the district court erred by holding that the context for each of these republications was necessarily the same, the entire rap battle, and that it should have performed a separate context assessment for each. The argument is without authority and meritless. Drake did not tell the court below that it needed to do separate context analyses. He barely raised republication, conceding at oral argument that there was a lack of grappling with and perhaps due to imprecise briefing on our part, this is a quote, Let me back up. He barely raised Republication, conceding at oral argument that there was, quote, a lack of grappling with and perhaps due to imprecise briefing on our part, the nature, the role that Republication plays in this case. I remember that, end quote. Drake's effort to inject this issue now comes too late. Regardless, the argument is meritless. Republication under New York law occurs upon a separate aggregate publication from the original on a different occasion that is intended to and actually reaches a new audience. Drake's Republication argument is undone by his admission that Not Like Us immediately became ubiquitous, generating a record-breaking 13 million streams in 24 hours, debuting at #1 and reaching 96 million streams in a week. He nowhere explains how later plays of a song already heard on that scale reached a new audience in subsequent republications. Put differently, if the track was non-actionable opinion at the outset, it did not morph into fact as more people heard it and learned about this rap battle. Nor does Drake cite authority requiring a separate context analysis for every later airing of the song. His theory would invite the multiplicity of actions previous case warned against. This court's Cooper decision confirms the proper approach. There, plaintiff alleged that statements made by defendant in May, June, and July of the same year defamed her by accusing her of being racist. The court held that all three statements were non-actionable because the reasonable audience would have understood them as blah, blah, blah. The court did not do separate context assessments for each statement. It assessed them in view of the broader context applicable to all. The only even remotely relevant authority that Drake offers is Condit versus Dunn. Condit applies California law and involved a new statement accusing the plaintiff of committing murder 4 years after the defendant had made a series of statements accusing plaintiff of the same. There, defendant's initial series of statements had already been the subject of their own action that resulted in a settlement. Drake otherwise cites cases about whether alleged republications are time barred, whether statements were published with actual malice, and cases articulating New York's fact versus opinion test. None support doing separate contextual assessments of alleged republications. Not only is Drake bereft of authority, but the argument would elevate form over substance because separate context assessments would not be different. What is at issue for each purported republication is Not Like Us, either in the form of the recording, the video, or live performances. In every case, the context, the forum, language, tone, and broader circumstances that gave rise to the song is the same. Republication cannot transform Lamar's statement of opinion into UMG's statement of fact. Drake's argument is just another attempt to divorce Not Like Us from the broader rap feud with Lamar. Drake's contention that the district court was wrong because Lamar's mental state is entirely irrelevant misses the point. The court was not concerned with Lamar's mental state, which goes to malice and only if Drake had sued the real subject of his frustration, which is Kendrick Lamar. Footnotes, baby. Footnotes are the best. The court was not concerned with Kendrick Lamar's mental state, which goes to malice, and only if Drake had sued the real subject of his frustration. The court meant that Not Like Us, taken in context, conveys opinion, and that analysis does not change because the song, in its same form, was purportedly authorized by UMG to be played in different venues after its initial release. Okay. Drake's argument is just another attempt to divorce Not Like Us from the broader rap feud with Lamar, arguing listeners at the Super Bowl and political rallies could have understood the statements in Not Like Us as standalone assertions to be taken seriously. And while the argument misunderstands New York defamation law for all the reasons discussed, it fails even on Drake's terms. For example, 3 republications, Grammys, Harris Rally, and DNC convention involve playing the recording at new venues. Again, it is illogical and wrong on the law to suggest that playing the exact format of the track would be republication, as discussed. Moreover, the reasonable viewer of the Grammy Awards is someone more likely to know about the rap beef between Drake and Lamar, especially as the feud had been in the media for 9 months. And Drake's resort to the Democratic National Convention is even worse. While noting that the recording was played during the roll call vote, Drake fails to mention that it was excerpted. So the audience merely heard the lyrics, "They Not Like Us," on repeat, but not the lyrics Drake claims are defamatory. Drakey poo. Drakey poo. Boom, boom, boom. Excellent point about the Grammy audience. Excellent point about the convention. Even if the audience had heard those lyrics, Drake's contention that political junkies who tuned into a political convention in summer 2024 would not have been familiar with the feud between Drake and Lamar is nonsense. Thank you very much. I said the exact same fucking thing. I was so deeply offended when he said that. I am a Politico for 27 years. And I was all over this. I was all over. It is those two things that brought me to YouTube. It is the fact that I am a strategist that brought me to YouTube to discuss Not Like Us and what the impact was going to be. And me saying, let me explain to you why Drake has just crossed over into the afterlife and will never be the same. That was so goddamn offensive and just such a faulty thing to say. It's absurd. It's absurd. That's like saying people who fish don't like ice skating. What? It is exactly me. It is exactly me to the T. It is absurd and desperate and rude. That's rude, sir. Political junkies who turned into a political convention in summer 2024 would not have been familiar with the feud between Drake and Lamar. That's nonsense. Drake pleads the convention was reportedly viewed by approximately 20 million people across 12 television networks. Surely he cannot contend that 20 million people had no knowledge of a feud that had gained cultural ubiquity. Oh, man, boy, they given this boy the white glove face slap treatment. These quotes that they are using are from Drake's own filings. And this is the wonderful thing about when people contradict themselves on paper. When people literally throw spaghetti at the wall and see what sticks. First, the judge was too broad, then the judge was too narrow. Well, if she wasn't overly broad, then she was too narrow. Boy, that's not how it works. I was incensed by that. Surely he cannot contend that 20 million people had no knowledge of a feud that had gained cultural ubiquity simply because they have some interest in politics. The same is true of the Harris rally video that went viral on social media. Lamar's live performance of Not Like Us at the Ken and Friends Pop-Out Juneteenth concert was, as the name indicates, performed at Lamar's concert, which would attract an audience familiar with his work and the feud. Similarly, The context of the Super Bowl performance undoubtedly put a reasonable viewer on even greater notice of the feud than the original non-actionable track itself. Reporting about the feud and whether Lamar would play Not Like Us was rampant pre-performance. Lamar also made references to this lawsuit in that performance. I want to play their favorite song, but you know they love to sue. Oh, I feel like shaking some titties. Woo! This is fire. This is fire. They are just knocking them down, clearing them out. Reporting about the feud and whether Lamar would play Not Like Us was rampant pre-performance. Lamar also made reference to this lawsuit in that performance. I want to play their favorite song, but you know they love to sue. This expressly contextualized the rap beef for the audience. Drake also fails to plead that UMG had any responsibility for publishing, even indirectly, Not Like Us, at the Super Bowl. He says only on information and belief that UMG conferred financial benefits on the parties in charge of the Super Bowl performance and leveraged existing business relationships to secure Lamar's headliner spot. Finally, the music video was released after the song had already become a hit and the subject of substantial media attention related to the feud. And its imagery seizes on the feud for the audience, including Lamar beating an owl piñata and staring down an owl in a cage. It is not reasonable to suggest the average viewer would see it as making standalone factual assertions. And so all of that 66 pages of 83 pages was for defamation. One hour, 38 minutes. I'm reading my ass off. So now we move on to harassment. Drake contends that Not Like Us violates the penal law. The claim fails because, as the district court held, this state's criminal statute does not provide a private right of action, and for other reasons not reached. So I'm not going to read this whole thing. I'm just going to encapsulate it for you very easily, okay? This is a civil lawsuit, which has been dismissed. And in the civil lawsuit, Drake cites penal, criminal law for his second-degree harassment claim. And the courts have already determined that there is no private right of action, that means civil lawsuit, for that specific statute. And that is the thing, by the way, when I said at the beginning of this, Drake wants to have a portion of this appeal kind of cut out and sent back for reconsideration on a matter that is settled law, has to do with these things. So, you know, they go through and they knock down Drake's arguments on, yes, I can. Yeah, no. They again say that Drake misapplies case law, which at this point, we've come to expect. So this is just all very technical, reminding the court of actions already taken by the courts. Yeah, I'm gonna move past. There's a lot of just dense case law references to the court. So one of the things that Drake says is that UMG had no reason to publish. Not like us. No reasonable reason to do so. And that therefore the only reason they could have published it and then licensed it, right, and continued to license it for its use was to harass Drake. He says that once he informed them that there had been an attempted break-in at his home, that from that moment on, UMG should have stopped licensing the song. He demanded they take down the video, and in his lawsuit, he wants a disclaimer put on the video, which it sounds like Kenny already took care of. But anyway, all jokes aside, he says, yeah, from the moment you knew that I was being harmed, allegedly, because he has shown no evidence that the song caused any of the things that he alleges happened to him after it. He just says the song happened, so it must have been the song that caused these things. And that from that moment on, of notifying UMG of those incidents, they ceased to have any reasonable reason to license the song, which is absurd because I think they're a record label. And they distribute music. So Drake fails to allege that UMG acted with no legitimate purpose in publishing and promoting Not Like Us. No legitimate purpose means the absence of a reason or justification to engage someone other than to hound, frighten, intimidate, or threaten. As Drake admits, UMG's motive was financial. Again, they quote Drake's filings back to Drake. Third, Drake cannot satisfy the requirement that UMG engaged in a course of conduct or repeatedly committed qualifying acts. Course of conduct statutes are constitutional only because they. Oh, never mind. I'm gonna script that. Okay. So that's all they had to say about second-degree harassment. I mean, there was quite a bit of case law in there, but yeah, the majority of this is focusing on defamation. They need defamation to go away, for sure. And now they get to general business law, the botting accusation. The court properly dismissed Drake's GBL claim. The district court properly dismissed the GBL claim because Drake fails to plausibly allege that UMG engaged in a deceptive scheme to inflate the popularity of Not Like Us, or that any conduct at issue was consumer-oriented. Plaintiff must allege that 1, the defendant's conduct was consumer-oriented, 2, the defendant's acts or practice was deceptive or misleading in a material way, and 3, the plaintiff suffered an injury as a result of the deception. Drake's claims on information and belief that UMG engaged in deceptive acts and practices by covertly financially incentivizing third parties to play, stream, and promote the recording and making materially false and misleading representations about the recording's popularity to consumers. I don't think that he particularly cares, and I think that, you have to pay attention to the court levels at which these cases happen, and the assumption that the Afro Man case has an impact or on Drake's case in some meaningful way is a completely separate conversation about local courts and federal courts. Drake's baseless allegations of a covert scheme by UMG to drive streams are made on information and belief, predicated on a handful of largely anonymized online posts. A small sample of users' possible experience communicated through tweets and other anonymized commentary fails to establish a plausible inference that UMG manipulated listeners into streaming Not Like Us. So, for example, one of the things that Drake quoted in his lawsuit in this section was the viral clip that was going around on social media that somebody, said, "Hey, Alexa, play something having to do with Drake," and it played Not Like Us instead. I was very disappointed to see just how stupid people are, that they thought that that was real. But even things that are laughable, right, and obviously doctored, Drake is using them as if they are fact and saying, "This, see, users of Amazon were misdirected to my music. I've been harmed." He puts his whole 6 tray of biscuits behind stuff like that in his lawsuit. And it is seemingly absurd, but you have to prove its absurdity in court. And if it's not on the court record, then it's not going to be considered by the judge. The judge doesn't walk into court like, "Well, I've heard all the songs. Here's what I think," unless they were ordered to submit the songs onto the docket. But just the judge was home on a Sunday and, before all of this, heard all the songs and has a personal opinion of, "Well, I think Drake sucks and I think Kendrick is better and I think this is absurd." You never saw that in the oral arguments when we heard what the judge had to say. You didn't see it in any of her rulings or on her motion to dismiss. She's dealing with matters of law and she takes it as seriously as any other case because these matters are serious. I'm just saying. I'm starting to get a little light. I don't think I've eaten anything all day. Like I said, both ends of the candle burning over here. Drake's allegations, based on what boils down to unreliable online commentary, fail the tests of the standard to bring forth this particular claim. And then they go through again a bunch of case law. And then Drake labels these ordinary rules, those standards that I just mentioned, as a heightened pleading standard. But the district court quoted Arista and Trombley, the very cases Drake invokes. What Drake really seeks is exemption from any meaningful pleading burden. The inquiry should have stopped once he said information was purely within the possession and control of UMG. That is not the law. Drake largely disregards the above authorities and instead primarily relies on other case law. And then they get into a tennis match of case law. Drake does not seriously contend that his few allegations are sufficient under governing law, only briefly addressing them. Drake has only two fact allegations about any activity by UMG in connection with Not Like Us. The first internet post, which Drake says was deleted and he did not preserve, supposedly linking UMG to a slow-ass digital marketer paying to clown the suit, i.e., not to promote Not Like Us. The second anonymous post says that UMG and Lamar use bot streaming. Given Drake's absence of basis for information and belief allegations, he resorts to the kind of distortions that necessitate the withdrawal of his original allegations under threat of sanction. He assertedly pled comments from a rapper with industry knowledge that UMG used artificial streaming to spread the recording. That would be Mr. Budden. I know Kendrick used bots. I know. You didn't know? I knew. That's the only way you can win a beef against Drake. I knew it. I totally knew it. To claim that Drake pleaded any such strong assertion is false. He actually alleged that a podcast host claimed that Kendrick used bots. It's in the document. My job is to read you the document. It's in the document. What? He actually alleged that a podcast host, and they put podcast host in quotations, shade. He actually alleged that a podcast host claimed that Kendrick used bots so Drake would have more dislikes than likes without referencing UMG. Drake's remaining allegations are more speculative. 2 X posts from July 2024 showing Not Like Us being recommended to Spotify users who search for rap artists, permitting plaintiffs to proceed on conjecture sourced to anonymous social media would defang case law and flood the courts with baseless claims and conspiracy theories. The court correctly dismissed. The court found that Drake did not plead facts indicating how any of the so-called deceptive practices allegedly employed by UMG harmed consumers. And this third action, general business law action, is consumer-oriented. Let alone how any consumer decision could be affected by the supposed deception. As the court understatedly observed, the amended complaint is somewhat vague as to who the class of consumers is and what product, goods, or services they are purchasing. Drake claimed only that UMG engaged in practices to make Not Like Us seem more popular than it actually was without connecting that activity to any consumer harm. He did say that he was the consumer, though. He said he was the artist and the consumer. Drake fails to show otherwise here. He contends only that the consumer-oriented conduct could be any repeated acts of deception directed at a broad group of individuals. This is in tension with the Court of Appeals' recognition that the conduct must result as a transaction in which the consumer was harmed. Words matter, y'all. Finally, this court can affirm on the alternative ground that Drake fails to allege a cognizable injury as a result of the alleged deception. Injury cannot be indirect or derivative, as when the loss arises solely as a result of injuries sustained by another party. But Drake's theory is each time the recording was artificially streamed, Drake's songs received a disproportionate share from the pool of royalties collected based on the streaming data, and every time the recording was played on the radio, Drake lost the opportunity for one of his songs to be played, let alone any other music artist on the planet. No, there's only 2 artists who have music that is available. It's either Drake or Kendrick, and if you are streaming Kendrick, then Drake is missing streams, because obviously you're not also streaming, like, I don't know, Fleetwood Mac, Shaka Khan, Mumford and Sons, I don't know, anybody but Drake. Drake? At best, this is a derivative or indirect injury theory because it is contingent on harm to third parties. the purported harm to streaming platforms and consumers that Drake loosely claims were deceived by UMG's supposed scheme to inflate the popularity of Not Like Us. Regardless, it is pure speculation that a Drake song would necessarily have been played instead of Not Like Us. I'm feeling smart. Throw $2 at the Docket Fund. Support your girl. Insert MAGA Minaj. What about me? GIF here. Biscuit Hannah. Conclusion. This court should affirm motion to dismiss. Baby, that's 70 pages in 1 hour and 55 minutes.
High five. I'm bulletproof.
I'm tired. So, yeah. Thank you very much. I'm damn hungry. So there we have it. UMG has officially filed their brief to the appeals court in Drake v. UMG. They whooped him a couple times. They whooped him a couple times in this document. And boy, to be a fly on the wall in the discussions around Iceman, as they've spent the last, 90 days working on this response to Drake. Now, mind you, that's retained outside counsel, not necessarily in-house counsel at UMG, but nevertheless, hostile working environment. Anybody? I don't know if Roland Ransom is an appellate attorney. We can look. Nope, I don't think it is. It looks like Amon P. Joyce, Sidley Austin out of New York. Amon. So appeals are, all law is specialized law, but appeals are its own special thing, right? Like you get 90 days to write this document, and it takes you 90 days to write it. So typically lawyers who are litigation attorneys are typically not also appellate attorneys. So he has his existing attorneys who brought the case forward, and now he has appellate attorneys as well, at least one, probably more than. If the case is restored back to the lower court, it'll go back to his regular attorneys, and same for UMG. UMG has its group of attorneys that handled litigation, and then they have their attorneys that are handling the appeal. It's a great name. Roland Ransom is a great name. Well, court approved tatas for everybody. So what can we expect to see next? As I said, Drake has filed a special request asking for a part of this to be carved off and sent back to the New York Court of Appeals on a matter that is already settled law. UMG filed their opposition to that, a decision at some point in time. And this is kind of one of those, appellate court is different because they dictate the schedule in a way that's different than the lower courts do. There's no limit on when things could come from an appellate court. But at some point in time, they will decide whether or not Drake gets that carve out. In that deciding whether or not Drake gets that carve out, they will decide whether or not to stay the appeal pending the New York Appeals Court ruling or, reconsidering what they've already settled because Drake thinks he's special. Or if they just say, we'll leave that carve out, we're going to continue with the calendar as we've set it so far, and we'll get back to that, depending on what New York does or doesn't do. So at some point in time, and when I say in some point in time, I mean in the next 6 months, they'll make that decision. And I would anticipate, unless other things are taking up their capacity, that at some point in time, probably much sooner than 6 months, we may get an amicus brief from rap scholars or anybody else who feels like they have something compelling for the court to consider. I can't imagine anybody more compelling than the rap scholars. Certainly not Michael Eric Dyson. Maybe he'll file an amicus brief about how the song de-blacks. He filed an appeal. Period. You ask him why he filed an appeal. Don't ask me. I didn't do it. I didn't do it, and for damn sure, I am not his representative. Queen Medina, why is he filing this again? Doesn't he have a heap of other lawsuits to be concerned about and a bevy of lawyers to deal with them? He filed the appeal because this is what works for him. And I know you know that. You just don't like it. And that's okay. That's perfectly valid. But he filed the lawsuit because that's what worked for him. He avoided suing Kenny because that's what worked for him. And he's filed the appeal because that is what works for him. It's as simple as that. And because in theory, in Drake's world, there's hundreds of millions of dollars in damages on the table. And since, according to a declaration filed by Lucian in the original litigation, Drake didn't get the contract he wanted, he's trying to get money out of UMG a different way. And this is it. By the way, it's good to see you. I can't remember if I said that already, but it's good to see you. Yes, you know it. Yes, you don't like it. Child. It really does. The Rolling 60s. He said, Jay said, Rolling Ransom sounds like a Latino Crip set to me. You're not alone. You're not alone. It is a name that says, I ain't nothing to fuck with. You know? So you're not alone in that. All right. Are there any questions for me related to this lawsuit before we cut up and act a fool? I'm baiting. That's hilarious. I think it's a Hail Mary, last-ditch effort, and I think it's settled law, and he's not special. This case isn't a this case is not alarming to the legislative intention of the law. Doesn't rise to that level. And it would create judicial inefficiency. I don't think he gets it. That's just my opinion for funsies. No, I don't at all. This is at the appellate stage. They're citing cases out of appellate court. Afro Man has no impact on this case, period. I do not understand the question. Can you rephrase or give me more specificity into what it is that you mean? This is Ron Ransom. No. No. UMG didn't ask for attorney's fees. They won. They won. So here's the thing. For corporations like UMG, lawsuits are a business expense. So much so that even though it's actually costing them money when they're dealing with litigation, they will chalk it up to no expense incurred, and therefore no damages for expenses. So UMG, in theory, with a dismissed case, would have been well within their right to petition for attorneys' fees and costs. They're not going to do that. It's just a business expense. Also, insurance companies are also involved in these types of cases. So whether it's coming out of just their typical line item business expense for legal stuff that happens in the course of business, or the insurance company said, we're footing the bill because we can't pay this motherfucker $1.5 billion in damages. We'll pay for the lawyers to get this case dismissed. We don't know that, and we're never going to know that. I hope that answers your question. My ability to think is leaving quickly. So they have what they call in-house counsel, which is just the lawyers that work for UMG. And then they probably work with very specific external law firms on a case-by-case basis when they need to just be like, here, this is yours. We need you on this one. So we haven't seen in-house counsel on much of anything since the very, very beginning of this case. The problem is I don't really have an appetite. I'm working on it. I'm running through my mind to think about what do I want to eat. That sounds really tasty and mouth-watery. I'm just not there yet. I haven't found the words yet, but where did he go to school? This man is nothing to play with. entertainment, sports and media, commercial litigation and disputes, and IP litigation. Where did he go to school? He's on the law firm's inclusion committee. I hope that goes well for you, Roland, because law firms are being targeted for those things. But anyway, it might not say. Oh. Oh my gosh, this is so funny. I'm not putting this on because his phone number and email address and everything are right there very, very boldly on the website. Roland Ransom serves as co-leader of Sidley's global commercial litigation and disputes practice and of the entertainment, sports, and media group. He is a managing partner of the Los Angeles office and also head of the greater Los Angeles litigation group. This man eats, sleeps, and shits the law. Roland's leadership extends to Sidley's firm-wide inclusion committee. Okay. He represents individuals and corporations, extensive experience prosecuting and defending lawsuits involving a wide variety of intellectual property claims, including copyright and theft of idea, trademark, false advertising, trade secret, and unfair competition actions. University of Michigan, nice. Magna cum laude. Experience, the top thing on his experience, obtained dismissal of headline-grabbing lawsuit brought by Grammy-winning artist Drake against Universal Music Group in the Southern District of New York, arising out of UMG's distribution of the Kendrick Lamar recording, Not Like Us. Yeah, he's got a bunch of accolades, credentials. He's admitted to practice in Second Circuit Court of Appeals, 5th, 6th, 9th, U.S. Court of Appeals Federal Circuit, District Courts, Eastern of California, Northern of California, Central of California, Southern of California, Northern of Illinois, California, Illinois, New York. Also went to Northwestern. Clerked for a U.S. District Court judge. Yeah, this dude ain't none to play with. That's absolutely right. Look at you. Look at the people who pay attention. I love this. Yes. 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 So this is a case where he has a robust knowledge and experience of appellate law, and this is the same law firm that is representing UMG in the litigation, I believe, is representing UMG in the appeal. So different lawyer's name on it, same firm. So he might not be lead counsel on the appeal, but he's still very much in the know of how the appeal is being handled. Yeah, he ain't nothing to play with. He ain't nothing to play with. Any other questions? If you had a question and I missed it, I'm sorry. You can post it now, and then we're going to get to the super chats. That's what he looks like. That's what he looks like. He looks like somebody who decided to use their power for good. To the best of their ability. We're all faulty in some way. But yeah, that's exactly what he looks like. Yeah. I can either be the lawyer for the penguin or yeah, for sure, for sure. Oh, you're so welcome. I'm happy to be here, truly. Well. I was not planning on showing this today, but I felt like there were so many people, and there's a lot of people here right now. Hello. We have a lot of insider jokes on this channel. Hyperbole is one of those insider jokes. We were just talking about the merch stickers the other day, and I was saying I have a couple concepts. This is one of them. I wasn't planning on showing it, but then this dropped, which I completely had forgotten about until last night. I was like, I feel like something is happening, and it was Drake v. UMG. So I felt like it was. I know what tends to happen when there are a bunch of new people and they hear me say hyperbole and they flood the chat and the comment sections with, "You don't know how to pronounce words, motherfucker. I don't see you reading anything on the internet." But anyway, I decided to throw up one of the drafts. So that's that on that. I think it's hilarious. It's not the only concept. There's another one that I'm not sure how it's going to play, but I love it. I'm not going to show it to you tonight because I don't feel like it. But this one is hilarious. I am tempted to show you one more concept that I came up with because you people are so inspiring to me. It's Friday. I feel like you've been good, you know? Hold on, let me find it. I'm finding it. And then I'll read the super chats. If you're wondering, I do now have a concept for meow meow 1 2 3 4 meow. I'm not gonna show it to you just yet. Okay. Damn it, where did it go? There's a lot of mock-ups. A lot of mock-ups. I decided that he needed a tuna bagel sandwich named after him called the Plaintiff Poppy, so you can pat yourselves on the back for that. Mm-hmm. There's also, and just please remember that these are mock-ups, so things can be adjusted a little bit. This is one where I see some things that I want to adjust, but I'm going to show it to you anyway. Be nice. I'm an artist, and I'm sensitive about my shit. That's another one. And then y'all tell me what you think about this last one. I think it's hysterical, but I think it also really speaks for itself, but maybe the connotation is lost on most people. We'll see. Personally, I think this is hilarious. I think the ring is an obvious reference. Does the ring appear to be an obvious reference for you? Oh God. The sandwich came from Sandra. I'm just saying. I think it's hysterical. Genuinely hysterical. This one right here, boy. I was like, this is genius. Give me a number 12. Plain and Poppy. Oh my God, so funny. Oh, that's right. She was supposed to buy it at the store, not make it. That was my complaint. My complaint with Sandra was naturally she did not buy the ingredients to make the tuna bagel at home. No. Terrible parenting. Well, he loves rings so much. I felt like his love of rings needed to be immortalized. This is hilarious. Karaoke and vodka. Ironically, I read the origin of the tuna sandwich in Exhibit A on the train today. She got a grape sandwich instead. That's right. If you're wondering what Exhibit A is, it's a book I wrote. This damn lawsuit. Yeah. But this is so funny to me. Also, I'm very proud of myself for the design work on this. Very, very, very proud. Very proud. You too can buy Bloodlines and Battle Rhymes, the first book, which is about the beef. And then the second book is Exhibit A, which is about the lawsuit. And as I was reading through UMG's brief to the appeals court, I didn't realize this stupid light is on this damn mic. I was thinking to myself, there was a little voice in my head like, if he wins appeal, you're going to have to write a third book. Yes, I know, bitch. I know. It's grape jelly. Okay, I'm going to tell you. Shh. I'm going to tell you some white people shit, okay? You ready? Hold on to something. I'm going to tell you exactly what it is. Because if somebody tells you that it's peanut butter and jelly, they a damn lie. Grape jelly, cream cheese on a bagel. The mayo thing is a lie. So somebody said, Angie says, hey, beautiful. Angie says, that sounds nasty. When I was little, my dad used to melt cream cheese, put it in these little cups, and give us a stack of graham crackers. And that shit slapped. Cream cheese is actually pretty sweet tasting. He didn't put any sugar in it. There was no grape jelly either. But it would not surprise me if so-called brothers put jelly in it. So when I think of it as a child snack food, I can understand the appeal of that. I still think about the graham cracker cream cheese concoction that my dad had. It's not even a concoction. It was just melt, he would just heat it up in the microwave or on the stove, not like to piping hot, but get it really, really warm and soft. Scoop it into just this little tiny bowl, and then you would get a stack of graham crackers, and we would sit and go to fucking town, scrape that bowl clean of the cream cheese, eat every graham cracker. And looking back, I'm like, that was cheap and totally satisfying. That was a cheap, easy, totally satisfying dessert. I still think of that with fond memories. But I would not want cream cheese, grape jelly on a fucking bagel. That sounds like sensory fucking torture. Cream cheese is one texture. Jelly is another texture. And then you got the bagel. What is this? What is this? I like my mac touching yams, but this is a bridge too far for me. I will eat. I will eat graham crackers and cream cheese. Play with me. Thick, slimy, dry, nope. It's the combining them on a bagel for me. I agree with you. That is also criminal. That is criminal activity. It has to be like a sweet cracker cookie kind of thing. But a bagel is crazy. Graham crackers are surprisingly versatile. Surprisingly versatile. Does that make it worse or better? Goldilocks, was the bagel even toasted? Probably not, since it was store-bought. That was just, they smear one side with cream cheese, they smear another side with jelly, and then they wrap it in saran wrap and they throw it in the deli section. So since they put it in the deli section where it's getting some type of refrigeration, it's even harder than just a fresh bagel. You can't leave a bagel with cream cheese in the dry goods aisle. It has to be in the deli. Wrap it up in that clean wrap. We've all seen the deli bagel sandwich, no matter what's on it. They wrap it in that cling wrap, stick a sticker, price sticker on it, chuck it, make the next one. Yeah. You can't just buy some bagels and some cream cheese and some. Maybe you couldn't, but maybe you could buy one, prepared one. And I don't. But I felt like it needed to be immortalized, and it's hilarious. I love it so much. So thank you all for the inspiration. And I question that anyway when I'm looking at deli prepared foods of the how long has it been sitting there. I'm questioning that anyway. Like, I assume you lying by at least a day. I really do. I assume you are lying by at least a day. All right. So, Sharina, who I mentioned earlier, thank you for the contribution. Alana, thank you. Clifford, thank you. Broderick, thank you. Fiona, appreciate you. Michael, thank you so much. Appreciate all of y'all. Claudia got us kicking off the chat. Go, appreciate you. Cell TV, thank you very much for the super sticker. Demetrius, appreciate you. Hey, Tori Michelle, hope you're doing well. Thank you for the support. Butterfly collection. Oh, it's great to see you, beautiful. Thank you for the contribution. Mrs. C60, it's great to see you too. I feel like I haven't seen you in a little while, but I'm also slightly delirious. So I could have seen you yesterday and I forgot about it. Charge it literally to my head, not my heart. Thank you so much for the contribution. Raphael, thank you very much. Appreciate you. Goldie Vox for the Docket Fund, thank you. D2B2. Good to see you, beautiful. Thank you so much. I'm frustrated that I don't know how to pronounce your handle. Thank you for the $5 contribution. Twilight Style, thank you so much. Hope you got around safely out in them streets. Huron, good to see you, beautiful. I can't believe this jabroni is still dragging this out. Yeah, babes. Nisi, thank you so much. Appreciate you. Karaoke and vodka, thank you. Thank you very much. I love your photo. You're beautiful. Thank you for the $10 contribution. Jamaria, hopefully I pronounced that correctly. T-Mac, thank you so much. Appreciate you. Appreciate your support. Beloved Bone. Love what you do, Queen. Thank you so much for the $2 contribution. Really appreciate you. That's a gorgeous wedding photo. Spooky Ariel for the goal. Thank you, beautiful. J-Dub, Duck Lips, Docket Fund. I gotta make another fucking sticker. The way Princey just jetted, he was like, oh, is she really mad? Let's go. Move it along. My boy went from asleep to, oh shit. I'm sorry, baby. He's all fluffed up and confused. I didn't even know he was over there. You okay? He's like, bitch, don't talk to me. You didn't even jump out your seat like it was real. Oh, God. Took me out. Nisi, thank you so much. Boom, boom, boom. Yes, there will be boom, boom, boom merch too. I ain't going to go there with you yet, but there will be boom, boom, boom merch. For the goal, appreciate you. BX Finest, it's good to see you. Hey, helping to get there. Thank you for the second one. Appreciate you. Oh my goodness, my tummy. Feed me, Seymour. T-Mac, thank you again for the super sticker. 99 cents. I appreciate you. That dude, Curtis 6. Thank you so much. There are certain things that I will say, and Princey's like, let me at least stand up and see what's about to happen next. See what's about to happen next. Also in how I say it, right? If I'm like, oh fuck, no reaction. If I go, fuck, he's gonna be like, let me at least open one eye, glance around, see what's going on. If I say fucking get up out of my chair, he's like, I'm up. I can go lay downstairs. It's fine. Unfortunately, I done traumatized the boy through a certain period of my career, which I'm not going to talk about because that would just lead to a bunch of bullshit. But through a certain portion of my career where I was dealing with beep redacted and also beep redacted and also beep redacted and then a bunch of like beep redacted and then the beep got assigned to it and then beep and so there was a lot of fuck in me getting up out of my chair. And so from that year point, he has learned, let's just clear out. And it's sad because it's been several years since beep happened. But Princey is one of those cats where if it happens twice, it's a rule. Yeah, if it happened twice, it's a rule. That's how it's going to be forever, 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 forever. So. I do like Supak Shakur's. That one is, it's witty. I don't know if I'll be able to do anything with it, but we'll see. The concepts are getting harder and harder and harder. You have no idea how proud I am of this damn sticker / magnet situation with this bagel. You have no idea how proud I am of myself. I am creative professionally. You give me a work task, I will creatively knock that shit out of the park. Right? This was hard. This was hard. Like I said, I thought about Hyperbole for almost 2 years. You guys have been asking me for merch for Hyperbole. I developed and had other people develop concepts and they just did not land right. The bowl in Hyperdrive did come to me a long time ago, and I thought to myself, maybe it's too literal or too simple. Excuse me. But in the course of, designing 50 different things over the past 8 weeks, I've readjusted my thinking away from those kinds of assumptions and just said, make it. Just make it. Put it in the concepts file. Look at it the next day and see how you feel about it and decide if you want to develop it. So that's what I've been doing. Simple sometimes really is the best. And like I said, I've got a couple other concepts that I really like that I think are, there was one that came to me the other night where I was like, oh God, wow. Breakthrough. But the bowl and the hyperdrive, I was like, that shit is just, it's perfect in its own little way. Hyper bowl. I was like, I don't know which you want me to say. Also, I'm a sci-fi nerd and I love space. So I was like, yeah, it's on brand for me, for real. Coming and going, that's on brand for me. So, yeah. What else is going on, guys? It also fits with the airlock. Yeah, I mean, it fits a couple things where I was like, it's funny, it's literal, and it's me. And that's another thing where I'm like, it's real easy to just pick a God, words are starting to escape me, y'all. Graphic. That's it. It's real easy. It can be time consuming. It's real easy to just pick a graphic and, oh, that's cute. And, oh, that's funny. And blah, 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 blah. And slap some text on it and call it a day. I promise you, I don't do that with any of the things that I am designing. The stickers are going to have to come out in like first wave and second wave, and then probably a third wave later. But because I'm also ordering as many of them as I can possibly afford, right? That I'm actually going to be selling, having them expedited to my home, so that I can see them, feel them, put them on something, test them out. So, you may see things today or yesterday that when the first wave goes up onto the website, they're not there. And it's because I'm not comfortable selling it to you yet, even though as I've said before, I really trust um, the company that's doing the production. They do really good work. It makes me feel better to see as many different variations of things. And there are some instances where I don't need to order a copy of something because I've already ordered something that has enough of the same components that I'm curious about in something else that I've already ordered. So it's just a kind of round robin process of concept, design, approval, send it off, get the mock-up, approve that, pay for it. So, and it's a nice little fun thing that makes me cackle. And I appreciate it. Thank you so much. I appreciate you. Yeah. Anybody going to a No Kings rally tomorrow? I'm not about to rag on you, and I'm not negatively judging you. I'm genuinely curious if anybody is planning on going tomorrow. Yeah. And also, there's been plenty of times where something gets mocked up and it's like it doesn't work. It doesn't work. And then you have to go off and you have to do a lot of thinking too, right? There's also the thinking stage of, can I come up with something in my brain to even throw a concept together that could eventually be a final design of something? And that's for everything. Bags, hoodies, t-shirts. It's like, can I come up with something, first of all, that makes me go, that's sick? And isn't just like, here's some merch, spend your money. Come on now. Not going. Okay. Staying in the house. Weekend birthday. Yep, they do need their little baby intro to protesting on the weekend when it's super safe and they have a permit. Yep, they do need that. And that's why I'm not going, because I'm not a baby protester. I got big girl panties. So when they're serious about it and they stop, first of all, let's remember that No Kings was done. Let's remember that they scheduled this over 90 days ago. Let's remember that this protest allegedly is in response to ICE killing 2 people in Minnesota. They waited 2 months. And I can promise you, because of my experience working in beep, that it doesn't take that long. I can promise you, it doesn't take that long to organize a nationwide action. So in case you forgot, that's what this weekend's No Kings protest is about. But they were done. They had changed their website to talk about No Kings as a past thing that was no longer happening anymore, and encouraging people to, participate in small D democracy in their own backyard and, get to know their own state's legislative agendas and get prepared for the midterms and make sure you're registered to vote. Like, it was over until ICE killed 2 people. And then a bunch of people, including me, said, where the fuck did them No Kings motherfuckers go? You can protest? Because that was I went to their website fully expecting them to be like, this weekend nationwide. And that's when I saw like the retrospective, No Kings is over. And I'm sure they got a lot of shit. I'm sure for the people that organize it, they had people reaching out to them. And I'm sure for the people that organize it, there were people in that organizing group that were like, nah, we're not done. Nah, we're going to have to come back. Nah, we're going to have to do it again. And the reality is they should never stop. And this is one of the reasons why I do not like them. I do not like that they only do it on a weekend. I do not like that they only do it permitted. I do not like that they keep trying to be like, all right, we did our part. We're out. Motherfucker, we got 3 years left of this administration. What do you mean you're done? That tells me the status quo within your organizing body is scared and uncomfortable and probably white and inexperienced. It's a failure. It is a failure. I think it is great that more people are going to these things because, as somebody said earlier, they need the practice. They need to get comfortable with stepping outside of their house because they're in opposition of something and using their body and their voice. Yeah, all of that is true. But if No Kings is not prepared to direct people from a Saturday to a Wednesday, this is symbolic outrage. It will not sway lawmakers. You know what sways lawmakers? Sitting in their offices locally, where they are this weekend because Republicans ran out of DC today. Couldn't run faster so as not to deal with the ICE funding legislation. So they're home in their home districts. You should be getting arrested, sitting in their offices, chaining yourself to their office furniture. And after you get arrested, the next wave of people should come in and get arrested. And when they get arrested and the administrators somehow are successful in locking the office door, that's when you sit in the lobby. And then you get arrested. And then that wave gets taken off to jail. And the next wave comes in, sits in the lobby. And then they get arrested. And as they're dragging them out and they're somehow able to lock the front doors of the building, that's when you occupy the block. My hope is, though, because this is my observation over just my lifetime, personally and professionally, and also, being one of the many generations that is the sandwich generation, right? Which is that I've got kids, I listen to and I respect their perception and experiences, but I also grew up not just with parents, but with grandparents. So my perspective is rooted generationally. And I think the decentralization of any freedom movement is essential to its success. And I think one of the things that we've seen, well, I know for a fact, one of the things that we have seen since Dr. King was assassinated, Malcolm was killed, even Bobby Kennedy, is there comes a point in time where it's not about The leader is about the cause. It's not about the spokesperson. It's about the organizing. It makes targeting freedom movements much more difficult. It can also make organizing them more challenging. But it's a much more organic, people motivated internally versus being swayed solely externally. And also standing behind somebody else to do it for them, to say it for them, to go to jail for them. And increasingly what you see is people saying, fuck it, I'm outside. We saw that in Minnesota. We saw white people in Minnesota who were like, I've been sitting my ass at home, fairly fucking comfortable while my city is being terrorized, and I wanted to see it for myself. You have people who were just so overwhelmed and so upset that they just came out of their homes to scream shame at the federal government and at law enforcement, just to scream shame. I get chills because those things matter, and those are the things that lead to a critical mass of people affecting an actual change in the world. I said all of that to say that no Kings ultimately is going to fail because it's not willing to go from a Saturday to a Wednesday. But the people who participated in it, not in totality, but nevertheless a significant portion of them, they will be ready to go from a Saturday to a Wednesday. And by the time they get to that point, they won't need no Kings to lead them. It just becomes about who's going to organize the Wednesday. And that will happen separately from no Kings, because those organizers are not about shit. I said what the fuck I said. A weekend is not an inconvenience. And that's why they keep doing it. And it breaks my heart a little bit every time it happens, because you also have to be careful to not waste people's goodwill, right? You can't overpromise them something. You know, I don't like it when, you know, the ACLU will send out a blast or post on social media, sign this petition to tell the Supreme Court not to overturn. That's not how the fuck the Supreme Court works. And the reality is a lot of people don't know that. And you are giving them the false hope that if enough people sign on to a thing, you can sway the outcome of a Supreme Court decision. You can't do that. They do that a lot with legislation too, where they will conflate issues and, you know, tell lawmakers this, that, or the other, which is not the same as, you know, when it says sign this petition, that's some fucking bullshit. When it's this is the bill number, this is how you figure out what district you're in and who your lawmaker is, that's different. That's an action alert for real business. All that other shit is performative nonsense. And I hate it, because there have been plenty of situations where people have thought, wait a minute, I thought we took action on this already. Wait a minute, I thought we did something about this already. Wait a minute, I thought when the mayor said during the protests that XYZ meant that XYZ. Well, no, that was a moral statement, not a policy change. Not a policy change. If you did not leave the BLM streets in 2019 and go into the BLM legislative session in 2020, you failed. You failed. You cannot sit back and expect lawmakers to deliver on the promises they made to you in desperation because you shut their city down. You actually have to meet them in the halls of the Capitol, where you are there to testify, where you're there to sign in on a bill for it or against it, where you're working with your community to propose legislation with your lawmakers. If you did not go from the streets to the legislative session, you failed. If we do all of this for years and federal legislation does not change about how federal law enforcement operates in this country, that is a massive failure, not of lawmakers, of the people who elected them. Oh, now I want cake. Yes, the church protest in Minnesota is a classic example. It wasn't even about being seen for them. It was about locally, right? The national press and all that stuff that happened was a bonus on it. But what I said was some people are more interested in being the ones to do the thing than they are interested in making sure the thing gets done right. And those are not your leaders. Those are egos in leader clothes. You need to tell them to go make copies and collate packets and step back. And if they say, well, I'm going home, then they don't give a fuck about the movement either. They only care about attention and praise and accolades and being considered the person that should be given credit for a thing happening. It makes me sick. Makes me sick. And it's the death knell to progress in our communities. So, anyway, beloved people, I'm going to go find me some food because I am fading fast here. As I said, no Friday Night Live tonight, unfortunately. I'll be perfectly honest with you. I had come up with an alternative to what we usually do. Number one, because I was exhausted and I just didn't have time to build it out the way that I do. But number two, because UMG typically does not wait until midnight to file their shit like Drake does. And I had a feeling that it would happen either right before Friday Night Live or it would happen during Friday Night Live and I would have to cut it to go start a new live. So I was like, I'm not going to do all the work of getting all of the assets together for a traditional Friday Night Live. Because I have a feeling it's going to go by the wayside. So efficiency, yay me. But I intend to catch up with you again this weekend. If it's not tomorrow night, then it will be Sunday evening, and we'll just have the final Friday Night Live of the month on either a Saturday or a Sunday. But we'll see how it goes and take it from there. I appreciate you all for hanging out with me, for getting this update. It felt good reading this document. I've kind of missed reading, UMG's lawyers' writing is really, like, as you can see, I tend to get into it. It's harder with appeals documents because there's a bunch of case law that breaks up the momentum that you got to skip through. But I was like, man, I remember this. I remember what this feels like. We've read a lot of various documents on this channel for various cases, and nothing has quite hit the same sweet spot as UMG dismantling Drake with his own words. It's just delightful. I don't know what else to say. So shout out to the replay crew. Sorry that you weren't here with us in live time, but I look forward to seeing you in the comment section. Thank you all. See you soon. Peace.